Judgment in the matter of Bilta and others against Tradition Financial Services and Nathanael Eurl and another against Tradition Financial Services.
These appeals raise two distinct points of statutory interpretation, arising from the assumed facts about a large-scale VAT fraud, commonly called Missing Trader Inter-Community or MTIC Fraud, which took place in the period May to July of 2009. The first involves the interpretation of Section 213 of the Insolvency Act 1986. I will call it Section 213 for short. It asks whether the persons who may be required to make contributions to a company's assets because they were knowingly parties to the company's fraudulent trading are confined to those involved in the management or control of the fraudulent business. The second question is whether the claims of two of the claimant companies, which had been dissolved and later restored to the company's register, are time-barred. It raises a question of how the test in Section 32(1) of the Limitation Act 1980, which postpones the running of time for a fraud claim until the claimant could, with reasonable diligence, have discovered the fraud, concealment, or mistake, operates during the period of the company's dissolution. The complex facts about the fraud do not need to be described in any detail, although some key dates need to be borne in mind when describing the second question. The fraud was committed in connection with spot trading in carbon credits under the EU Emissions Trading Scheme, also conveniently known as EU allowances or EUAs, which in 2009 attracted VAT. 5 UK companies were directly involved in the fraudulent trading of EUAs, of which 2, Nathanael Eurl Ltd, which I'll call Nathanael, and Inline Trading Ltd, which I'll call Inline, ran up large surpluses of VAT receipts, which their directors then dishonestly paid away rather than accounting for them to HMRC, and leaving their companies exposed to large claims by HMRC without any funds with which to meet them. The common defendant in these proceedings is Tradition Financial Services Ltd, which I'll call Tradition, which provided brokerage services to the 5 companies involved in the fraud, including to Nathanael and Inline. The assumed facts include that Tradition had sufficient knowledge of the fraud for their services to amount to dishonest assistance, both in the fraudulent trading by the 2 companies and in the misapplication of their VAT receipts by their directors. After being abandoned by their directors, Nathanael and Inline were each struck off the register of companies and dissolved in February 2011 and December 2010, respectively, and then restored to the register and placed in compulsory liquidation on the application of HMRC in March 2012 and June 2015, respectively. Their liquidators issued claims against Tradition on 8 November 2017. The liquidators claimed that Tradition was liable for assisting in fraudulent trading under Section 213, and the 2 companies claimed compensation for Tradition's dishonest assistance in their directors' misapplication of the VAT receipts in breach of their fiduciary duties. In a partial settlement of those claims, Tradition has agreed to pay the same undisclosed sum in respect of each of the Section 213 and dishonest assistance claims, subject to losing on one or other of the 2 issues of law which I have already summarised. Tradition says that it was outside the scope of Section 213 because it was not involved in the management or control of either company, and that the company's claims in dishonest assistance, but not the Section 213 claims, are time-barred because they could, with reasonable diligence, have discovered the fraud while they were struck off. Tradition lost on the Section 213 issue before the trial judge and before the Court of Appeal, but Nathanael and Inline lost on the time bar issue, again at trial and before the Court of Appeal, although for different reasons. Both Tradition and the 2 claimant companies were given permission to appeal to the Supreme Court. This court unanimously dismisses both appeals. Lord Hodge and I deliver a joint judgment with which Lord Hamblin, Lord Burrows and Lord Richards agree. Our reasons follow. Taking the Section 213 issue first, the section provides, and I'm quoting, if in the course of the winding up of a company it appears that any business of the company has been carried on with intent to defraud creditors of the company or creditors of any other person or for any fraudulent purpose, the following has effect. 2. The court, on the application of the liquidator, may declare that any persons who were knowingly parties to the carrying on of the business in the manner above mentioned are to be liable to make such contributions, if any, to the company's assets as the court thinks proper. The key words which are decisive of this issue are any persons who were knowingly party to the carrying on of the business of the company with intent to defraud creditors or for any fraudulent purpose. Those are clear and unambiguous general words, the ordinary and natural meaning of which is not confined to those actually managing or controlling the company's business. By contrast, the language of surrounding sections of the same part of the Insolvency Act 1986 is directed expressly at insiders, such as directors or officers, or those concerned in the promotion, formation, or management of the company. This part of the language of what is now Section 213 was in 1947 deliberately widened from the language of Section 275 of the Companies Act 1929, which limited its scope to directors and shadow directors, and this change was made on the recommendation of the Cohen Report in 1945. Consideration to the purpose of Section 213, namely to discourage fraud, does not point to a narrower construction of the critical words, nor does the ambit of the similarly worded provision in Section 993 of the Companies Act 2006, which creates criminal liability for participation in fraudulent trading, support the insiders-only interpretation submitted by counsel for Tradition. There's a stream of authority, both civil and criminal, which is either supportive or at least consistent with the interpretation that Section 213 and provisions with similar language are not limited in their ambit to those who manage or control the company's business, even though none of the reported cases prior to the present decision of the Court of Appeal constitutes binding authority. The second point is more complicated. It turns on the interaction between Section 32 of the Limitation Act 1980, which provides for the extension of the time limit for bringing claims, among other things, based on fraud, and Section 1032 of the Companies Act 2006, which provides that where a company is restored to the register, then it is deemed to have continued in existence as if it had not been dissolved or struck off the register. But first it is necessary to set out the chronology. The normal limitation period for bringing a claim for compensation for dishonest assistance is 6 years, so it would have run out in relation to this fraud by July 2015. But the companies were then struck off and dissolved in February 2011 and December 2010. They were restored in March 2012 and June 2015, but their claims were not brought until the 8th of November 2017. Section 32 of the Limitation Act 1980 postpones the commencement of the 6-year time period for bringing a claim based upon fraud until the claimant either discovered the fraud or could with reasonable diligence have discovered it. Thus, in the present case, the question is whether the two companies could with reasonable diligence have discovered the fraud before 8th November 2011. It was common ground that, for as long as the two companies were managed by their fraudulent directors, they could not be said to have discovered the fraud. The question debated in these proceedings was whether either company could, with reasonable diligence, have discovered it at a time when it was in fact struck off and had ceased to exist. Nathanael and Inline advanced the case at trial and upon appeal that in the absence of any direction from the court to the contrary under Section 103(2)(3, and there had not been one when each company was restored to the register, it had to be assumed that each company had no directors or other officers capable of exercising diligence in the discovery of a fraud while it was deemed to have continued in existence, although in fact struck off. Alternatively, they argued that their former fraudulent directors would have remained in office, whose knowledge of the fraud could not be attributed to the companies. The trial judge concluded that Section 103(2) required that while a company is deemed to have remained in existence, it had to be assumed that it had honest and reasonably competent directors. He therefore concluded that both companies could have discovered the fraud using reasonable diligence before 8th November 2011, so that Section 32 of the Limitation Act did not assist them. The Court of Appeal did not accept that Section 1032 said or provided anything about what directors or officers a company would have had, if any, during a period when it was deemed to have remained in existence, while in fact struck off. The question was one of fact to be proved by evidence. Since the burden of satisfying the condition in Section 32 for an extension of the commencement of the running of time lay upon the party seeking to rely upon it, and neither Nathanael nor Inline had advanced any evidence at all upon the point, their attempts to rely upon Section 32 failed. This court agrees with the analysis of the Court of Appeal for two main reasons. The first is that the deeming provision in Section 1032 should be interpreted no more widely than required by its underlying purposes, which did not require any assumptions about whether the company had directors or officers while deemed to have continued in existence. The second is that if a struck-off company is always to be deemed to have had no directors or officers while struck off, then a company which has incurred the penalty of being struck off would always be able to rely upon Section 32 to postpone the running of time in its favour, whereas Section 32 was intended only to assist deserving applicants. While the question whether a struck-off company would, had it remained in existence, have had any directors or officers of any particular competence or honesty is a counterfactual one, the answer to it is nonetheless a question of fact, dependent upon evidence, in relation to which the party relying upon Section 32 bears the burden of proof. For those reasons, these appeals are dismissed. The court is now adjourned.